Modes of acquisition and loss of territorial sovereignty. 1. Introduction. Territorial sovereignty is the right of a state to exercise exclusive jurisdiction and control over a specific geographic area. In international law, territory is the fundamental foundation of a state. Without territory, a state cannot exist. The rules governing how a state acquires or loses land are largely derived from old Roman private law principles regarding property. 2. Modes of acquisition of territorial sovereignty. There are 5 traditional modes recognized by international law through which a state can validly acquire new territory. A. Occupation. Occupation is the intentional claim of sovereignty over a territory which is terra nullius, land belonging to no one. Essential ingredients. 1. Terra nullius. The land must not already belong to any other recognized state. 2. Effectiveness. The claimant state must exercise actual, continuous, and peaceful control. Mere discovery is not enough. There must be a settlement or administrative presence. Example: the island of Palmas case, where the court emphasized that continuous display of authority is more important than mere discovery. B. Prescription. Prescription is the acquisition of territory through the continuous and undisturbed exercise of sovereignty over a long period, even if the land originally belonged to another state. Essential ingredients. The possession must be peaceful and uninterrupted. It must be public, not secret. It must last for a long period, though international law doesn't specify the exact number of years. Difference from occupation. Occupation applies to no man's land, while prescription applies to land that officially belonged to someone else but was neglected by the original owner. Accretion. Accretion is a geographical process where new land is added to a state's existing territory through natural forces. Forms of accretion. Alluvion. Gradual deposit of soil by a river or sea. Avulsion. A sudden change in a river's course or a volcanic eruption creating a new island within territorial waters. Legal rule. If the change is gradual, the boundary moves with the land. D. Cession. Cession involves the transfer of territory from one state to another through a voluntary agreement or treaty. Types. Voluntary, such as a sale, e.g., the USA purchasing Alaska from Russia. Compulsory, usually occurs after a war via a peace treaty. Rule. The transferring state cannot give more rights than it actually possesses. Nemo dat quod non habet. E. Conquest. Annexation. Historically, a state could acquire territory by defeating another state in war and annexing its land. Modern status. Under the UN Charter, the use of force is prohibited. Therefore, acquisition of territory through conquest is no longer considered legal in modern international law. Modes of loss of territorial sovereignty. Just as territory can be gained, it can also be lost. The modes of loss generally mirror the modes of acquisition. Cession. When one state acquires land via cession, the other state loses it. Dereliction. Abandonment. This is the opposite of occupation. It happens when a state leaves a territory with the intention of giving up sovereignty and no longer exercises control. Operations of nature. Territory is lost if land disappears due to natural causes, such as a volcanic island sinking into the sea or massive soil erosion. Subjugation. Loss of territory through defeat in war. Though illegal today, it remains a historical mode. Prescription. If a state fails to object to another state's presence on its land for decades, it may eventually lose its legal title. Revolt. Secession. When a part of a state rebels and successfully establishes itself as a new independent state, e.g., the creation of Bangladesh in 1971. 4. Conclusion. The stability of international borders depends on these rules. While natural processes like accretion continue to change maps slightly, the most common modern method is cession through treaties. Today, the principle of self-determination and the UN Charter's prohibition on force have made conquest an obsolete and illegal method of expanding a state's borders.